Thank you, Arshit. Good evening, everybody. Before I start the session, I would like to thank BJN Publisher, Homeopathy 360 team for giving me this opportunity. I would also like to thank Dr. Mansi Madam for her cooperation and support. You all are doing excellent work in the field of homeopathy. It's my privilege and honor to be a part of this webinar series. I have chosen this topic, medical negligence, because now there is an increasing number of cases day by day, and patient is also aware of the negligence, and they are filing the complaints day by day. So let's start with the today's topic. I'm sharing my screen. I'm audible. Harshit, I'm audible.
Hello, hello.
Okay, hello.
Ma'am, you are audible and your screen showing properly.
Okay, fine. Thank you.
Okay, ma'am, you can continue.
Okay. When a healthcare profession such as doctor, nurses, and hospital does not follow proper medical care while treating the patient, it can cause harm to the patient, and this mistake in medical care can lead to either minor injury or the serious injury or even the sometime even the death of the patient. This mistake is called the negligence. Today we are going to understand about the medical negligence with example, type of negligence, punishment if we do not follow the medical ethics in practice, how to prevent negligence in practice, and how to defend against the negligence. And today we discuss and find the conclusion from the real cases of medical negligence and filing the case of negligence. Okay, before I start the session with the medical negligence, let's understand another term, that is medical malpractice. Both are not the same terms, medical negligence and medical malpractice. Medical malpractice includes unfair, unethical medical practice that are incorrect and improper. In medical malpractice, rules and regulation are not followed properly by the doctor. So, because of that, medical malpractice occurs when a healthcare provider or doctor knowingly violates the standard of care and leading to harm. The provider is aware of the risk but fail to take appropriate action and makes a reckless decision. Here, 2-3 components are there in malpractice. One, doctor is knowingly violates and fail to take the appropriate action and makes a reckless decision. Whereas in medical negligence occurs when a doctor makes an unintentional mistake that causes harm to the patient. There is no intention to harm the patient, but the doctor failed to meet the standard of care due to carelessness and oversight. So there is basic difference between negligence and malpractice. Our keywords are a mistake due to oversight and carelessness, that is negligence. Whereas in malpractice, doctor is conscious decision that disregards the standard of care. Here, doctor is conscious about his decision, and even though he disregards the standard of care. Let's understand the example. A nurse is accidentally administered a wrong dosage of anesthesia because they misread the chart. And because of that, patient experience complication but recovers after some additional treatment. This was an unintentional mistake due to carelessness, making it medical negligence. Another example, the anesthetologist realized that patient's vital signs indicate distress but chooses to proceed with the surgery without adjusting the anesthesia. As a result, the patient suffered brain damage due to lack of oxygen. This medical malpractice because doctor knowingly ignore a serious risk. Here, key differentiation is nurse error was negligency because it done accidentally and unintentional mistake. Whereas anesthesiologist's decision was reckless and he is aware of the risk. So two components are different and so two terms are different. Let's start with the basic topic, medical negligence. Definition is a want of reasonable degree of care and skill or willful negligence on a part of medical practitioner while treating a patient, resulting either bodily injury, ill health, or the death of the patient. Here, two components involved in the definition. One is want of reasonable degree of care and skill, and second, on the willful negligence on a part of medical practitioner. Medical negligence occurs when a doctor fails to provide the expected standard of care, resulting in unintentional harm to the patient. It is typically caused by carelessness, oversight, and mistake rather than deliberate wrongdoing. Here, this component carelessness, oversight, and mistake done by the doctor. Doctor is not doing it intentionally. Example, a doctor misread a patient's test, result and mistakenly tell them they are healthy, leading to delayed treatment for a serious conditions. Let's understand two components. One is lack of reasonable degree of care and skill, and second, willful negligence. First, um, we cannot measure the reasonable degree of care and skill exactly, but we can cover the component of reasonable degree of care and skill. That is component of standard of care, comparison to the peer, and avoiding mistake. A doctor must have the same skill as an average competent doctor at that time and at that situation. They don't need to be the best, but should follow standard medical practice. Standard of care means a doctor must give treatment that meet the medical standard. Comparison to peer means a doctor care is judged based on what other skilled doctor would do. And avoiding mistake. If a doctor act carelessly, it may be seen as a negligence. So conclusion from above component is doctor must be competent enough to provide the treatment up to the medical standard and act responsibly to avoid the negligence. Secondly, willful negligence on a part of doctor while treating the patient. The doctor willfully neglect or disregard their duty of care, resulting in harm. This goes beyond mere mistake. It constitutes a deliberate failure to act responsibly. Doctor is not able to respond in and properly and maintain the standard of care. Let's understand, see the elements of negligence. Here are four elements are there. One is duty of care, breach of duty that leads to causation and that damage the patient. How these four are interlinked with each other? First, patient-doctor relationship established means duty of care established. This duty arises when a doctor agree to treat or to take care of the patient. However, doctor has the choice to select the case they taken on. A doctor can choose a case based on its severity, their skill, but once they have accepted the case, they are bound to take care of the patient. They cannot refuse, they cannot alter anything in these cases. That's breach of duty. Breach of duty, a doctor fails to meet the standard of medical profession while treating the patient either through act of commission or act of commissions. This breach could involve act of omissions means failure to do something necessary. जो necessary था वो डॉक्टर ने नहीं किया. और act of commission mean doing something incorrectly. जो करना था rightly वो नहीं किया. And because of this breach of duty, the causation means breach of duty directly harm the patient and patient injured. There must be a link between doctor's action and harm suffered by the patient. And because of that, damage occurred and patients suffer. Patients suffer actually harm and or injured, and this damage could be either on the form of physical, emotional, financial, or even some in cases, even the death of the patient occur. And all these components, all these elements are present, negligence is established. Let's conclude all this in a one phrase. That is, when a doctor-patient relationship established, a duty of care arises. If a breach of that duty occurs, directly causing harm to the patient and the patient suffer as a result, all these components indicate medical negligence has occurred. Okay, let's understand in detail about the act of omission and act of commission. Failure to do something, that is, doctor is omitting to do things which are necessary at that particular situation and for the particular patient. That is act of omissions. Failure to diagnose. A doctor failed to diagnose a condition or illness based on symptom or the test, whereas another competent doctor correctly diagnosed it. Failure to treat. Doctor failed to provide appropriate treatment after a diagnose the illness or neglecting the administered necessary medical intervention. Failure to monitor. A doctor failed to monitor the patient condition closely when the patient is in a critical state or undergoing procedure. Failure to refer. Doctor failed to refer a patient to a specialist or another hospital provider when it is necessary for a patient to give the immediate or the critical care. It is necessary for doctor to evaluate the situation and refer the patient at the right time. Failure to inform. A doctor failed to inform the patient about risk, alternative treatment, even the necessary follow-up care. Failure to take proper follow-up. Doctor failed to ensure that whether a patient received necessary follow-up care after a procedure, treatment or not. This all the component like failure to diagnose, failure to treat, failure to monitor, failure to refer, and failure to inform, and failure to take a proper follow-up. These all components are like an act of omissions. Next is doing something, committing something which an ordinary man is not supposed to do. That is act of commissions. जो नहीं करना था वो डॉक्टर ने किया, जो दूसरे डॉक्टर नहीं करते हैं वो सिचुएशन में, दैट इज कॉल्ड एक्ट ऑफ कमीशन. Wrong diagnosis. The doctor has misdiagnosed the illness, and because of that, incorrect treatment occurred and delay care. Surgical error, like performing surgery on the wrong side, leaving surgical instruments inside the patient body, or making another avoidable mistake during the procedure. Medical error, which is very common, administering the wrong medication, incorrect doses, or failing to account for allergies or intervention like other drugs. Inappropriate treatment, providing treatment that is not suitable to the patient condition, or using outdated procedure or outdated ways or harmful practice that could worsen the patient's conditions. Failure to sterilize equipment. Here, using non-sterile instruments or equipment during a procedure leading to infections or complications. Negligent anesthesia administration and improper medical procedure. performing medical procedure incorrectly, such as diagnostic test, radiological procedure, or another intervention which cause harm to the patient. Are you all understanding me? Please write down yes or no in the chat box. Raise your hand if you have any queries. These are the examples of medical negligence: misdiagnosis, delayed diagnosis, incorrect treatment, improper treatment, incorrect medication, surgical errors, anesthesia error, prescription error, hospital infection. We have seen in the black fungus infection during the COVID, failure to obtain informed consent and inadequate follow-up care. The classification of negligence. Negligence is a legal concept, not the medical concept. Why? Because it is not judged by the medical person. This is judged based on the legal rules and regulation and laws. Negligence is actionable, and action for negligence may be brought against the doctor in either civil court or the criminal court. On this basis, two types of negligences are there: civil negligence and criminal negligence. Civil negligence means civil wrong. Civil negligence is when a doctor failed to take basic care of the patients. In civil negligence, patient brings charges of negligence against the doctor for monetary compensation for damage suffered by him. Civil negligence cases, a patient has to approach civil court or the consumer forum or the consumer court. To be valid, the suit for negligence must be filed in civil court within 3 years from the date of alleged negligence. If the court has taken decision on a particular case, the same case cannot be reopened in any other court. This term is called res judicata. It is a private matter between the patient and the doctor, and the burden of proving the negligence lies on the plaintiff, that is patient. Patient have to prove that negligence occurred by the doctor. All evidence should be presented from the patient. If negligence is proven, the patient can be awarded compensation for damage like medical expense, pain, and the suffering or the lost wages. Under civil liability, compensation is the maximum relief provided to the patient concerned. So 3-4 points are there. One is patient is gain monetary compensation and damage suffered by him. Okay, let's understand the flowchart of negligence. Doctor-patient relationship existed, established. It's a doctor's duty to bound to treat the patient. Dereliction of duty occurs means breach of duty occurred, and because of that, patient suffered damage. And this damage should be compensated in terms of either money. Okay, let's understand the criminal negligence. Criminal negligence is an act beyond mere mistake. It's not simple a mistake. It's more than mistake. It is recklessly acting without reasonable caution and putting another person or the putting patient at the risk of injury or the death. Criminal negligence is a gross neglect act and had caused death or severe harm to the patient. The doctor show a gross carelessness or a gross neglect for the life of safety of the patient. It is something more than mere omission or neglect of duty. It shows there is a restlessness on the part of doctor. Here, the patient and the relatives of the patient bring allegation of criminal negligence against the doctor. In criminal negligence, the doctor is prosecuted by the police and the charge in criminal court. It is more serious than the civil negligence and is considered a criminal offense because here the gross negligent act is done and it's going beyond the matter of compensation. We cannot compensate the life of patients or the injury, irreversible injury occurred because of the negligence. In criminal negligence, the prosecution or police has to prove all the fact. To establish negligence and gross negligence by doctor and have to show that doctor has disregarded the life and safety of the patient. The doctor is liable to punish under IPC section like 304A, 336, 337, 338. We will see it in later slide. Example of civil negligence: a doctor who operate on the wrong body parts due to misreading a patient chart, and that may be a civil negligence. A doctor who misreads a chart and operate a different body part of the patient. Third, failure to obtain informed consent. A doctor perform a procedure without adequately informing the patient of the risk involved. If the patient suffer harm as a result, they may claim negligence for the lack of informed consent. कि डॉक्टर ने हमको इन्फॉर्म नहीं किया था ये प्रोसीजर से क्या हार्म हो सकते हैं, क्या कॉम्प्लिकेशन है. It is better to take a consent. Example of criminal negligence: operation on wrong limb, removal of wrong organ, wrong blood transfusion, leaving instrument in abdomen, performing criminal abortion. Let's understand from the chart. That is, all sides are compromised in this one slide. First, doctor treat a patient and negligence occurred and patient suffered injury. If this injury is minor in nature, patient seek monetary compensation from the doctor. Patient approaches civil court if the treatment was free, and patient approaches consumer forum or the Consumer Protection Act accordingly if the fees are paid and patient receive the compensation. That is all about the civil negligence. Let's take another things. If the injury is gross in nature, patient complains to the police and police bring action against the doctor. And the doctor is prosecuted in criminal court and the punishment is determined based on the extent of the injury. कितनी injury हुई है patient को. Like section, let's see the section 336 IPC is if no injury occurred but the doctor endangered the patient's life. Patient की life को threaten हुआ. That is called, that include in the section 336 IPC. Section 337 IPC, if hurt was caused. And section 338 IPC, if grievous hurt was caused. What is the meaning of grievous hurt here? Grievous hurt means patient lost the part of the body that is either hearing or the senses organ or the vision or the eyes or the sometime maybe the function of the joints or even the body parts. That is called grievous injury. This is irreversible injury. One cannot compensate it for it. Section 304 IPC, if death was caused because of the negligence, these all are the criminal negligence. Let's understand the another word, serious professional misconduct is also called the infamous conduct. Professional misconduct refer to improper or unethical behavior by the professional that violates the standard or medical code of their profession. It involves the action that are considered unacceptable, unethical, illegal within the professional community. As we all know that medical profession is a noble profession. So we have to perform in a particular standard, up to the particular standard. It involves an abuse of the professional position. Let's take example, issuing a false certificate to patient or other people That is also professional misconduct, and it is punishable under section 190A IPC. Some example of infamous conduct: dishonesty, providing a false information, lying, or misrepresenting the fact by the doctor. This is infamous conduct. Incompetence, failing to meet the required standard of competence or knowledge in the profession. Conflict of interest. If a doctor makes decisions that are influenced by a personal interest rather than professional duty, doctor taking a decision on the basis of his own interest rather than professional duty or treating the patient. Breach of confidentiality. The doctor disclose the private information about a patient without their consent. Doctor cannot disclose the information of patient to anybody. Abuse or harassment, engaging any form of inappropriate or abusive behavior toward the patient. Fraud or the theft, engaging in fraudulent activities such as billing for services not rendered, not given to the patient and issuing bill for it. Other avoiding unfair means secret remedies, prescribing secret medicines, patient snatching, associate with unqualified people, and violation of Prenatal Diagnostic Technique Act. These all are the example of infamous conduct. Before I go further, let's differentiate between the negligency and infamous conduct. Let's conclude in this way. Negligency is the absence of care and skill or willful negligence. It is a trial by criminal, civil court, or either consumer forum. And what are the punishment? Punishment may include either fine, compensation, or the imprisonment. In infamous conduct means violation of code of medical ethics by the doctor. It is a trial by state medical council. And what are the punishment given in famous conduct? That is either warning or erase of the name of doctor from the register. Okay. In negligency, the burden of proof of negligency lies in with the patient. Patient have to prove that. Patient have to show and collect the evidence and show that doctor have done something and neglect something. But one exception is there in which burden of proof lies with the doctor. And this condition is called res ispa liquider. Doctrine of res ispa liquider means things or the facts speak for itself. This doctrine applied to both the civil and criminal cases. In absence of negligence, injury would not have occurred naturally. Doctor have exclusive control over injury proceeding, instrument, and treatment. Here, patient have to prove that if doctor have not done these things, then he will not be injured. Let's take the example of it. Leaving foreign object like scissor, sponge, or any other object in the body of the patient will consider as an act of done due to negligence. Leaving a foreign object inside the patient after surgery or other invasive procedure, operating on the wrong limbs, operating on the wrong part of the patient and wrong patient, failure to remove swab during the operation, and loss of use of hand due to prolonged splinting. Okay. What are the punishments are given for the negligency? The section of IPC, that is Indian Penal Code, related to negligency have been replaced by the section of nowadays Bharatiya Nyaya Sanhita, BNS section, with some updated in the penalties and scope. Bharatiya Nyaya Sanhita section 106, causing death by negligence. If patient die because of negligency, then provision, this section penalize anyone who causes the death of another person by a rash or negligent act not amounting to culpable homicide. Punishment, imprisonment up to 5 years, or a fine, or both. Initially, the maximum punishment term has been increased from 2 years under IPC to 5 years in BNS sections, which reflect that stricter strains or the negligence resulting in the death. Bharatiya Nyaya Sanhita section 125, act that endanger human life or personal safety due to rash or negligent behavior. This section penalizes individuals who, through rash or the negligent act, endanger human life or personal safety of the others. The punishments are general, and if it is a general endangerment, imprisonment of up to 3 months and fine up to 2,500 or both. If hurt is caused, and imprisonment of up to 6 months and fine up to 5,000. And if it is a grievous hurt or the irreversible injury occurred to the patient, the imprisonment up to 3 years and fine up to 10,000 or the both. So two section BNS sections, section 125 and section 106 are for the punishment for the negligence. Okay. Now let's understand how the doctor can protect themselves once the negligence has occurred. These all are the defense points to deal with the negligence once it occurred. First, error of judgment. Doctor may say it's an error of judgment. If a medical profession make a reasonable and honest error in judgment while treating a patient, it may not be considered as a negligence. A second is emergency situation. If a medical professional acted in a good faith to save a patient's life in an emergency situation, they may not be considered a negligence, because in emergency situation, one have to take the decision in a short period of time. Third is contributory negligence. If the patient contributed to their injury or death through their own negligence, the medical profession may not be held entirely responsible. If patient ने कुछ ऐसा किया कि उसकी वजह से death हुई, that is a negligence is contributed by patient himself. So this is not responsible for a medical negligence by the doctor. Section 80 IPC said that Indian Penal Code state that nothing is an offense which is done by accident or misfortune and without any criminal intention or knowledge in the doing of a lawful act in a lawful manner by lawful means and proper care and caution. बट डॉक्टर ने पूरा ध्यान रख के किया है, पूरा रूल्स रेगुलेशन फॉलो किया है, डॉक्टर ने प्रॉपरली किया है, फिर भी कुछ हुआ, that is not considered as a negligence. Standard of care. The doctor must show that he had provided the standard of care that another expert doctor would give in the same situations. Inform consent. If the patient was informed of the risk associated with the procedure or the treatment and consented it, the doctor can argue that the patient was aware of the potential outcome and including complication. So to take the consent is the basic necessity to avoid the negligence. Let's see the point that doctor should consider to prevent the negligence. How to prevent negligence? Just taking care of some basic points and we can avoid the negligence and we can avoid the lawsuit. First is employ qualified staff and associate with the good partners. Hiring skilled staff, ensure high quality care and fewer mistakes. Accurate diagnosis. Correct diagnosis leads to the right treatment. It avoids errors and ensure the patient get the help they needed. Timely action. Quickly help prevent the condition for getting worse leading to better recovery and fewer the complication. Update your knowledge. Adhere to the standard of care. This is basic things. Keeping up with the latest medical practice. Ensure that patient receive the best treatment and reduce outdated practice. Effective communication. Take valid informed consent. Keep documentation of communications. These are the small steps, but very important for the record purpose and for the evidence purpose. Clear communication prevent confusion. Make sure patient understand their treatment and protect both the patient and doctor legally. Ensure reasonable skill and care. Provide care with the right skill, prevent mistake, and ensure the patient get proper treatment. Guard against the therapeutic hazard. Being aware of any avoiding treatment risk, protect the patient from harmful side effect or reactions. Handling emergencies. Responding quickly to emergencies help prevent further harm and can save the life of patients. Comprehensive documentation. Keep accurate medical records and complete record. These records, proper documentation keeps a clear record of the patient's care, helping avoid mistake and supporting any further treatment. Risk management protocol, identifying and addressing the risk before they happen and prevents problem and reduce the chances of legal issue. Timely patient follow-up helps in noticing problem early, reducing the risk of miscomplications, avoiding conflict of interest. Doctor have to make the decision based on the patient's well-being, not the personal or the financial interest. This builds the trust and prevent the bias care. Team collaboration ensure that all the team member understand their roles and responsibility. एक की गलती की वजह से दूसरे पे आता है और पूरा टीम का परफॉर्मेंस कम होता है और दैट इज कॉल्ड कि पूरे टीम ने नेग्लिजेंस किया. When everyone knows their roles, the team works together smoothly and important task has less likely to be overlooked. Patient safety culture, continuous quality improvement. Always improving care practice makes the environment safer for patient and reduce avoidable harm. Last, legal and ethical training. Training doctors and staff on legal and ethical rules and that ensure that they follow the right procedure and avoid negligence. So to prevent the measurement against the negligence, doctor have to take care of these all points. Let's start with the real cases of medical cases of negligence. First, understand the case one, then we can proceed with the what are the law outcomes are there and what are the component of negligence occurred in this case. First, Anuradha Saha, a 36-year-old US-based child psychologist, developed fever and rashes during the Kolkata visit in April 1998. She sought treatment from Dr. Sukumar Mukherjee, who initially advised rest. On May 7, she was wrongly administered a high dose of steroid depomedrol, followed by continued steroid treatment. Her condition worsened, leading to hospitalization at AMRI, where further inappropriate steroid use aggravated her condition. As her health deteriorated, she was shifted to Mumbai Breach Candy Hospital, where she succumbed to toxic epidermal necrolysis on May 28. Her husband, Dr. Kunal Saha, fought a 15-year legal battle that resulted in India's highest medical negligence compensation. This is a case where highest compensation was given. Outcome by the law, a Supreme Court of India rule in favor of Kunal Saha in 2013, holding Dr. Sukumar Mukherjee, an AMRI hospital responsible for medical negligence. The court awarded Dr. Saha a record of 6 crore in compensation, over 11 crore with the interest, making it as the highest compensation in a medical negligence cases in India till the time. So let's understood case and what are the point of negligence occurred here by the doctor. First, misdiagnose and delay treatment. Initial refusal to prescribe appropriate medication lead to worsening of the patient condition. First thing, overdose of steroids. Second, administration of excessive depomedrol and prednisone without proper evaluation of cause and severe complication. Third, failure in patient management. Doctors at AMRI fail to recognize and control the worsening reaction, contributing to fatal toxic epidermal necrolysis. A lack of standard care. The treatment violate establish the medical protocol, leading to irreversible damage and ultimately death of the patient. 4 points occurred: misdiagnosis, delayed treatment, overdose of steroid, failure in the patient management, and lack of standard care. Let's see the second case, very interesting case. Now, Krishna Rao, an officer in the Department of Malaria, admitted his wife to Nikhil Super Speciality Hospital on July 20, 2002 due to fever and chill. Despite medical tests and treatment, her condition worsened. On July 22, contaminated saline was administered, but the hospital ignored the concern raised by her family. Her family raised the concern about the contamination saline, but they ignored. The next day, she was put on artificial oxygen, which the complainant claimed was unnecessary. As her condition deteriorated, she was shifted to Yashoda Hospital, where she was declared clinically dead. It was later revealed that she had malaria but was mistakenly treated for a typhoid, leading to fatal complications. On the outcome by the law, the Supreme Court ruled in favor of Krishna Rao, applying the legal doctrine res ispa liquidator. The hospital was found guilty of medical negligence and ordered to pay 2 lakh in compensation. Let's understand what are the components of negligence occur. Her husband is a work. Her husband worked in the Department of Malaria, and even though he cannot save his wife. The first one is misdiagnosed. Instead of typhoid, instead of malaria, they diagnose as a typhoid case, and they given the treatment of typhoid. The hospital treated Mr. Rao for typhoid instead of malaria, worsening her condition. Because of that, patient condition worsened. Neglecting patient safety. Second one is neglecting patient safety. The hospital failed to address concern about contaminated saline, potentially exacerbating her health issue. Unnecessary medical procedure. Artificial oxygen was administered without proper justification. There is no need of it. Delay and ineffective treatment. Failure to correctly diagnose, manage malaria lead to fatal outcome. Misdiagnose, neglecting the patient safety, unnecessary medical procedure, and delay and ineffective treatment. These are the components of negligence occurred in this case. This is also a very interesting case. Samira Kohli, a woman seeking medical treatment for infertility, consulted by Dr. Prabha, a renowned gynecologist, for a laparoscopic surgery to remove a cyst from her ovaries. During the procedure, Dr. Prabha performed a totally hysterectomy with the bilateral salpingo-oophorectomy, removal of uterus and ovary without Samira's consent. How this can happen? Although Samira was temporarily unconscious under the anesthesia, the procedure was not an emergency and her mother consent was not considered valid as a Samira was an adult and her consent was necessary. The patient had only consented to diagnose an operative laparoscopy, not the removal of her reproductive organ. This is the main case and the main highlighting situation. Patient had only consented for diagnosing an operative procedure, laparoscopy, not the removal of the reproductive organs. Samira filed a complaint for the medical negligence, arguing that surgery was performed without her approval and that the operation caused unnecessary harm. Let's see the outcome by the law. The Supreme Court ruled in favor of Samira Kohli, holding Dr. Prabha liable for medical negligence. The court emphasized that medical practitioner must obtain informed consent from patient before performing any medical procedure, especially when it involves irreversible action like a hysterectomy. The court awarded damage to Samira Kohli for the harm caused. Let's see what are the points of negligence occurred here. One is lack of informed consent. This case shows how much important to take the consent from the patient, even though it is a small procedure or the major one. Lack of informed consent. Dr. Prabha did not obtain Samira's informed consent before performing a hysterectomy, a major procedure that was not part of the original treatment plan. Unnecessary medical procedure. The hysterectomy was performed without valid medical grounds and was not required for the condition Samira was being treated for. Breach of trust. Samira's trust was violated as she was not adequately informed about the risk and nature of the surgery being performed. Violation of patient's autonomy. This is very important. The decision to perform the surgery without patient's approval was a violation of her rights to make informed decision regarding her own health care. It's a patient right to take the decision about his treatment, about his procedure, etc. So 4 points are neglected here. Lack of informed consent, unnecessary medical procedure, breach of trust, and violation of patient's autonomy. This case is a case of homeopath. Mr. Pramod Verma, suffering from fever, was treated by Dr. Ashwin Patel, a homeopath who prescribed allopathic medicine and injection despite lacking the necessary qualification. The patient condition worsened, leading to his transfer to Hinduja Hospital, where he died. His wife, Poonam Verma, filed a negligence case against Dr. Patel, which was initially dismissed but later appealed to the Supreme Court. And so what are the outcomes of the law? That is, the Supreme Court held Dr. Ashwin Patel liable for medical negligence per se, as he unlawfully practiced allopathy without qualification. The court awarded 3 lakh in compensation and 30,000 in legal costs for the petitions. So this is a negligence per se, because after taking the degree of homeopathy, we cannot prescribe or we cannot practice the allopathic medicine. Another case of the homeopaths, Sangeeta, Srimati Sangeeta was admitted to a nursing home under Dr. Meena Pandey, who falsely claimed to be a gynecologist. She gave birth to the female child on 16 January 2014 through normal delivery. Initially, Dr. Pandey assured the complainant that both the mother and child were fine. However, soon after she requested the complainant to arrange blood. By the time he returned, his wife had died due to excessive bleeding, that is postpartum hemorrhage, as we all know. Later, it was revealed that Dr. Pandey held only a homeopathic degree, but had been prescribing and administering allopathic treatment without proper clarifications. The outcome by the law, the Uttar Pradesh State Consumer Dispute Redressal Commission found that Dr. Meena Pandey guilty of medical negligence and deficiency in service. The court highlighted that cross-pathy means practicing a different medical system without authorization or without license is a serious violation and imposed liability on Dr. Pandey. So, what are the negligency occurred in this case? That is, first one is false representation of expertise. Dr. Pandey misrepresent herself as a gynecologist without the required qualifications. Unauthorized medical practice. As a homeopathic doctor, she unlawfully administered allopathic treatment. Third, failure to manage PPH. She did not recognize or manage postmortem hemorrhage properly, leading to the patient death. Delay in arranging blood. Blood should have been arranged earlier instead of at the critical moment. Lack of timely communication. The patient's families was not informed in advance about the risk and necessary medical intervention. These 5 points are considered for as a negligence. First is false representation of expertise, unauthorized medical practice, failure to manage PPH, delay in arranging blood, and lack of timely communication. So all these cases, even though it is either a medical cases or homeopathic cases, the point of negligences are one by one. It is either we have seen the examples like delay diagnosis, delayed treatment, improper treatment, misdiagnosis, failure to manage the emergency, lack of timely communication and timely treatment. These all are the point to be considered. Okay, let's see how to file a medical negligence complaints. Identifying appropriate forum first. In which area or the which forum is suitable for the case to file. First, identifying appropriate forum. Consumer court, that is consumer according to Consumer Protection Act 2019. If you want compensation for the harm caused by medical negligence, you can file a complaint in a consumer court. Healthcare services are considered as a services under this act. Complaint can be filed according to the claim amount. Second is civil court. For causes involve compensation claim that don't fall under the consumer law, one can file a suit in civil court also. Civil court handle more complex and higher compensation claim, such as those involving significant financial damage, long-term suffering, or even when the negligence isn't directly related to a service under the consumer law. So civil cases are prosecuted in the consumer forum and civil court, whereas criminal negligences are prosecuted in the criminal court if the negligence is severe and has led to serious injury or death. You can file a criminal complaint under section 106 of Bharatiya Nyaya Sanhita. Once you have filed the complaints, second is to gather the evidence. Medical records. Collect all medical records, prescriptions, test report, bills. These documents are essential to prove that this negligence was occurred. Second is expert opinion. Take the expert opinion of on in it. In medical negligence, expert opinion from other doctor are often required to prove that the treatment provided was below the standard. Third, filing the complaints. For consumer court, jurisdiction, file the complaint in the district, state, or the national consumer court, depending on the value of the claim. First, district forum for complaint up to the 1 crore, state commission for claim between 1 crore to 10 crore, national commission for claim above 10 crore. For civil court, suit for damage, you can file a suit for damage in a civil court, explaining the negligence and the harm caused. Civil court handle larger and more complex compensation claims. Burden of proof, the patient must prove that the doctor and the hospital failed to provide the standard of care, leading to harm. Civil suit often require detailed evidence and expert opinion. For criminal court, file a FIR, go to the police station and file a first information report FIR under the relevant section for the Bharatiya Nyaya Sanhita such as section 106. Court proceeding start. The criminal court will conduct a trial. And if negligence is proven, the doctor or hospital may face the penalties like imprisonment and the fine. Here in criminal case, doctor have to prove that he didn't do anything below the standard and the patient suffered. It's not because of his part of treatment. Fourth court procedure, notice to the opposite party. After filing the complaint, the court will send notice to the doctor or the hospital or to respond to the allegation. Hearing, attend the court hearing where both the parties present their arguments. You may need to bring medical expert to support your cases. Decision, the court will give a judgment in consumer or the civil case. It could be compensation. In criminal case, it could be a punishment for the negligent party. 5. Appeal if needed. If you are not satisfied with the decision, you can appeal to a higher court. For example, you can appeal from the district forum to the state commission or from state commission to a national commission under the Consumer Protection Act. Thank you. This all about the today's session. Hope you all learn about the basic concept of medical negligence, how to file the case and how to prevent in your practice.
Thank you very much, ma'am, for your insights. It was a very valuable session, and all of us gained a lot of knowledge from this session. Now, I would like to ask anyone from the audience if any doubts they have. If anyone has any doubt, they can raise their hand.
So we have questions in the question and answer box, Harshit. Like Dr. Indranil is asking, kindly explain Bolam's case.
I'm not getting it, madam. Which case?
Ma'am, in the Q&A section, they have written the doubts.
Okay. I'm not understanding the question. I'm searching one by. Okay. We did not discuss the Bolsum case of 1957. So we have discussed the few cases of negligence, medical negligence and homeopathic negligence. We will discuss in later session. Harshit,
Yes, ma'am.
any other query particular for this session?
Any other doubts if someone have?
These are the few cases where we only understood through the real cases that what are the component of negligence occurs.
Ma'am, there is a doubt that is avoiding home visit is negligence in the Q&A section.
What? एक minute. Is avoiding home visit is a negligence? If it is a required or you have taken the cases, then it is a negligence. If patient require the immediate care and you have taken the case, means you have agreed to all the terms and condition of the patient. So it is a negligence.
Any other doubts?
If you have initial phase of the interrogation, you already told the patient about the you are not going to visit you have put your terms and condition, then if patient agree about for that, then it might be lower your negligence act. Another query is also if a homeopath refused to unknown patient a death certificate, will it amount to negligence? Issuing a wrong certificate is negligence, misconduct, but refusing to give a death certificate to a strange person or unknown person is not a negligence, amount of negligence. You are doing a right thing. You are following the rules and regulation of medical ethics. So it's not the negligence condition.
So, is there any other doubts from the audience?
Ma'am, I think there are no more doubts amongst the audience.
All right, madam. I think it's time to wrap up this session, the very first session of Homeo Talks 2025 with Homeopathy 360 and in collaboration with Padua University. And it was a wonderful session we had
Thank you, madam.
with Dr. Falguni Patel, ma'am. Thank you so much, ma'am, for your time and for sharing your, such informative insights. And you have shared the real cases, which was very interesting. And you made this session very informative.
Thank you, madam. I would like to thank Mansi madam for a cooperation and support. I would like to thank BJN Publisher and team of Homeopathy 360, madam. It's my honor. Thank you, madam. Thank
Thank
you.
you so much. I would like to thanks again Dr. Falguni Patel ma'am and Mr. Harshit Kumar. Thank you so much for coordinating this session very well. And the session went very smoothly. And thank you so much the all the participants who joined this session and made this very first session of this series of Homeo Talks. And I'm definitely sure that we are going to learn day by day as we
Definitely.
have as we have so passionate teachers, professors with us. Thank you
Yes.
so much, ma'am.
Thank you, madam. Thank you. Okay.
Okay, good night, ma'am.
Good night, madam.